this presentation today, we'll discuss why it's time for English law to embrace a duty of good faith in the performance of all contracts. Now, to briefly outline the overview of my presentation, I will start by discussing the current standings of English law in good faith. This will involve a discussion about the Court of Contract Law, how English law and good faith interact, why the courts are unwilling to adopt such a doctrine, and what would a positive path for English law and good faith consist of. I'll then talk about the current doctrines in place and the wide scope of promissory estoppel and misrepresentation. That will then take me on to talk about why good faith is nothing to be worried about, and the dichotomy between flexibility and certainty, and then why we need flexibility in English law following COVID-19. That will then bring me on to the discussion of the use of good faith in other jurisdictions such as Australia and Quebec with reference to Canadian law, and then bring me on to a final summary of why it's time for English law to embrace a duty of good faith. Now, to talk about the current standings of good faith in English contract law. English contract law is made to be black and white, current, with little room for interpretation. Essentially, English contracts should be watertight. Contracts are underpinned by honesty, trust, confidence, and cooperation, principles that work in harmony to create a mutual fairness between parties. Now, while good faith encapsulates this moral foreground of contract law, it does go against the traditional view of contracts as watertight promises and therefore is subject to various criticism. Now, looking to the current standings of English law and good faith. Good faith, as it stands, has been attemptedly defined in a number of cases, making it a concept of common law. And instances of attempting to define this obligation can be seen in a number of cases, but today we will focus on the leading case of Young Singh. Now, using Legat's interpretation of good faith, he draws out two key principles from previous authoritative sources. These principles are honesty and fidelity to the parties. Now, these principles do encapsulate the previously mentioned fundamental underpinnings of contracts, and therefore it is arguable that a doctrine should be put in place to categorise these contractual norms. If we look to other jurisdictions that use the concept, we can see that good faith creates a legal duty for contracting parties to abide by standards of contractual morality. So the question is, why aren't the courts willing to adopt such a doctrine? Well, as it stands, the concept of good faith exists to a larger extent in relational contracts. However, following the leading case, Young Singh, we are beginning to see a movement in the common law where good faith is being recognised in short-term contracts with only two parties concerned. We will recognise that the current use of good faith in English law is not objected enough, and if we are going to go as far as to adopt it as a doctrine, we need to ensure that English contract traditions are being upheld, namely certainty and consistency, which have been at the core of contracts since its creation. With this in mind, English law should trust the experience of successful jurisdictions such as Australia, France, Italy, and Canada, while upholding the current foundations of English law and make changes to a clearly outdated version of the law. So what would a positive path for good faith consist of? Well, a positive path would be the inclusion of good faith in English law, which is enshrined as an underpinning principle within all operating contracts. This would protect vulnerable consumers to the greater extent. Now, this presentation throughout will draw upon this need for change while upholding English contract law traditions. So moving on to current doctrines, we can see that English law has committed itself to no overriding principle of good faith, but it has developed piecemeal solutions in response to demonstrated problems of unfairness. Lord Bingham notes that the traditional hostility towards the doctrine of good faith is based on the fact that the courts are searching for particular solutions to particular issues rather than enforcing broad principles. However, these piecemeal solutions still remain broad in their interpretation. If we look to promissory estoppel, which creates binding of promises so parties can contract with confidence. In other words, promissory estoppel ensures that people are contracting in good faith. There have been authorities where estoppel has been incompatible with the binding laws of consideration, creating a contradiction between what should be complementary. The case of Central London Property vs High Trees is an example of this, where we can see a conflict induced between promissory estoppel and consideration, leading to a legal uncertainty. This case focused on the dependence of parties as opposed to the exchange of promises. This uncertainty then led to the case of Kenny versus Kelly, and the scope of promissory estoppel continued to expand. Now, this defeats the court's argument for the need to focus on particular solutions, as promissory estoppel remains broad in itself, and therefore its reluctance to adopt a principle of good faith is futile. Now, we should therefore consider an adoption of good faith. Moving on to misrepresentation, we can see a similarity to good faith as it follows a reasonable test and thus an objective test. Now, misrepresentation broadly covers the area when a party encourages another to enter a contract through a statement that turns out to be false and leads to the loss of an innocent party. Therefore, due to its objectivity, its interpretation is broad. Like good faith, misrepresentation is context dependent and therefore further defeats the purpose of legal certainty. Now, both these doctrines have a wide scope of interpretation and room for legal uncertainty. It therefore makes sense for good faith to be adopted as a broad understanding that can fill in the gaps of the law. Legal uncertainty has clearly not discouraged the enforcement of both misrepresentation and promissory estoppel, and therefore we should consider adopting a principle of good faith. So, why is good faith nothing to be worried about in the eyes of Lord Stine? Now, initially, we will look at the dichotomy between flexibility and certainty. Now, while the English constitution is highly recognised for its flexibility, the law of contracts actually favours legal certainty. Legal certainty is an outstanding principle in the contract law and should remain. It is a fundamental standard that participates in the offer and acceptance of a contract. However, changes do need to be made in areas such as drafting, interpretation, and the policing of contracts. We can see the success of legal uncertainty in Canadian law in the context of arrangement processes. In Anand Anita's article, she states that flexibility persists largely because the law relating to arrangements is principle-based, that it comprises of a series of standards that govern the structuring of a transaction. She then goes on to talk about a reasonable test which requires compliance with abstract terms. This can be compared to good faith, which according to Stine requires a reasonable test. Therefore, following Canadian law, the doctrine requires flexibility. So why do we need flexibility in English law? English law has the provision of frustration and related force majeure clauses. However, using the case study of COVID-19, the anticipation of a pandemic was likely. As a result, we have seen an impact on construction claims to at least 2023. As it stands, the doctrine of frustration is as flexible as the law gets in drafting, interpretation, and the performance of contracts. However, it is flawed. Now, whether a supervening event is frustrating or not, in a wide variety of cases, is a question of degree. And after the first lockdown, the chances of another lockdown were arguably foreseeable, and frustration could not come into play. This is where the need for the doctrine of good faith in contract law comes into play, and flexibility holds an utmost importance in this area of contract law. Good faith offers room for renegotiation and thus creates an alternative option for other than the termination of contracts. Therefore, if the UK plans to get the economy back on its feet following the financial loss with various businesses, wider room for contractual negotiation needs to be put in place with reference to all contracts as opposed to just relational. So we can see the need for flexibility following COVID-19. The British Institute of International and Comparative Law suggests that English law should look at how other systems deal with the same issues following COVID-19. So William Blair stressed that the new thinking is going to be required if English law is going to play a full part in getting international commerce back on its feet. Within the principle of legal uncertainty, space needs to be found for renegotiation. In other words, the possibility for renegotiation and flexibility needs to be found in order to improve our legal system, something that has been highlighted by the devastation of the pandemic. With this in mind, we will look at the Australian and Canadian and Quebec legal systems and how they approach the concept of good faith in contract law. So starting at looking at the Australian jurisdictions, it is similar to English law as good faith remains a creature of the common law. If there's any jurisdiction that is in a similar position as English law, it would be Australia. Now, J.W. Carter describes Australian contract law and good faith as unsettled and in a state of confusion, which mirrors Severine Sainter's depiction of the notion of good faith as misunderstood and controversial in English law. However, the Australian leading case, Renard Constructions, verified 3 propositions that make Australian law closer to finding peace with the concept of good faith. It outlines that the 3 propositions are: number 1, a requirement of good faith must be implied. Number 2, the source of the implied requirement of good faith is an implied term in the contract. And number 3, the implied requirement of a party acting in good faith is that they act honestly and reasonably. Following the judicial support for these propositions, Australian law has continued to grow at a fast pace, and its understanding of good faith as a principle in the law is increasing. So to look at how we can compare Australian principles of good faith with English principles, Lord Justice Morgan H in Berkeley Community Village versus Pullen boils down 3 elements of good faith. We will focus on the third principle, which is to be consistent with the justified expectations of the other contracting parties. Now, if we compare this to the Australian law principles, it is an expansion of the third principle. Now, perhaps English law is too specific with its interpretation of good faith, making it less adaptable to varying contexts. The Australian law is recognising progress for its ability to adapt to different cases, and therefore expanding its common law in the practice, and thus the principle of good faith itself. Now, moving on to good faith in the jurisdiction of Quebec, which is different to Canadian law, as good faith is incorporated in their civil code as opposed to an organising principle. The codification of good faith as a principle does have its clear limits, however. One cannot create an obligation to negotiate a clause that is duly negotiated by the parties, and therefore good faith does not require parties to out the interests of other contracting parties first. This limitation of codified principles ensures that although it has a broad interpretation, limits are in place to maintain an element of legal certainty. In reference to English law, the fear of good faith, like Quebec, the court can impose limitations to ensure that legal certainty is maintained to the largest extent and that parties cannot act beyond their limits. Now, to quickly summarise this presentation today, we can see that following the impacting circumstances of the pandemic, English law now more than ever needs to move away from traditional notice of legal certainty in the context of drafting and policing and towards a more flexible approach. This ensures that gaps that lie within the presence of unexpected events are covered, and contracting parties can maintain a relationship through renegotiation of terms. Now, current objections against good faith are more than commonly surrounding a fear of the wide scope of interpretation leading to legal uncertainty. However, current doctrines, namely misrepresentation and promissory estoppel, continue to expand and create room for interpretation, but they still remain enforceable in English law. This is evidence that wide scope doctrines are successful and are necessary in the law of contract. Now, turning to Australian jurisdictions, we can see the rapid increase of case law on the doctrine of good faith is solidifying a normative principle to be interpreted by the courts. The principle proposed by the courts are broad, but it appears to be successful as it stands. Following from this, it could be a step in the right direction for English law to follow their approach and adopt a broad principle in order to build case law and increase understanding of the doctrine. Finally, following Quebec jurisdictions, English law can protect a degree of certainty through the imposition of limitations to the term of good faith, and therefore police contracts in a somewhat restricted manner. It would be positive for the UK to adopt a doctrine of good faith in the performance of all contracts to protect those vulnerable consumers, and also allow a room for negotiation within contractual performance to maintain relationship between parties. Following Legat, we should recognise that principles underlying other jurisdictions and progress our normative values of contract law into a doctrine of good faith. Now, that does conclude my presentation today. I hope that it is taken into consideration and we will be able to see more why we should adopt a principle of good faith in the performance of all contracts.